here's the question. Okay, I understand the idea of the non-justiciable questions, which are political questions, which are typically questions how laws should have been legislated. You have and had and will continue to have the Supreme Court interpreting amendments to the Constitution, correct? Like they interpret the Second Amendment. They're going to interpret what laws. What's the word I'm looking for?
What does the law mean?
Well, no, does it? What law? So I'm just going to bring that up. What law is in conformity with the Second Amendment? What law is not? So when you have the Constitution, which says high crimes and misdemeanors, and I understand we say political questions are non-justiciable. If the question were to ever come to the Supreme Court, what is a high crime and misdemeanor? Interpret it in the same way you interpret the Second Amendment. Well, I have difficulty understanding how the court's going to say we're not interpreting what high crimes and misdemeanors is. It means whatever Congress says. In the same way, we're not interpreting the Second Amendment. It means whatever Congress says it means. And that's where I think that I don't know what I honestly don't know the Nixon judge decision well enough. Mm-hmm. But I would be shocked to understand or fully appreciate that the Nixon decision says we're not interpreting the Constitution, because that's exactly what the judicial branch is meant to do. And if Congress comes in and says high crimes and misdemeanors says whatever we say it means, therefore those words in the Constitution have no meaning, I would imagine the judicial branch would come in and say, no, the words have a meaning, and we're going to make sure your interpretation fits with that meaning.
Well, specifically, the Supreme Court, in the Nixon case, they made two very compelling arguments for political question doctrine. The first argument was if the Supreme, because of the words, they use an originalist textualist argument, saying the words of the act, not the act, the amendment, not the amendment, of the article of the impeachment article, specifically remove the role of the court. It says the sole power of the House has the sole power to impeach. The Senate has the sole power, and it was placed in Article 1, not in Article 3 or a different article where you could make a guess that other branches of government have some influence on it. So the Supreme Court in Nixon says, because of the language, that's the first argument, that it seems like the court doesn't have any role in this, and they went to the contemporary Constitutional Convention. But then the second argument that was made was that a separation of powers issue. The court isn't supposed to be a super legislature, and the fact that impeachment was a check on the court itself. If now the court can then go and say, well, listen, for instance, would you impeach Judge Pinkerton for drunkenness? That's not a high crime and misdemeanor. They said, and this is a very conservative Chief Justice says, that by being able to do that or interpret high crimes and misdemeanors, it effectively eliminates the check that the Constitution granted the legislature over the courts. And by doing so, that's why they can't now interpret high crimes and misdemeanors to be anything, because that was in the sole discretion of the legislature, and it's deemed a political question. Go ahead, Kirk. It seems like you want to jump in.
Yeah, I think the fact that impeachment, the clause exists for all federal officials, because there's only one impeachment clause, regardless of who you're impeaching. And so if we're trying to impeach a member of the Supreme Court, which has happened, then if the court can interpret that, then we have a real problem. Because it's like the Supreme Court can say, oh, we really like this justice, so we're going to say that doesn't count as a high crime, regardless of your impeachment, regardless of your conviction. And so this guy's still a Supreme Court, and now we have a constitutional crisis. So I agree with Nate on the language commitment. And another example of something that is wholly committed to one branch is the power of the pardon, which is wholly committed to the president. The president has the power of pardon. If he issues a pardon, it's valid. End of analysis, right? I mean, assuming the person accepts, because it has to be accepted. But, a court would never review a pardon for, like, did the president have good reasons or corrupt motives? I think even if the president literally took a bribe to issue the pardon is still valid because it's within the power. Now, that might be criminal because of the bribe. It might be impeachable because of the bribe, but the pardon itself is still going to be valid.
But you see,
because the way the power is structured.
Okay. I'm going to be stubborn, and I'm going to be pig-headed because I'm Canadian, and I'll say I don't understand the Constitution.
That's okay. We can explain it.
Okay. A pardon is not a subjective term that is susceptible of interpretation. A pardon is an act that is done or not done. So the question is never going to be, did he actually pardon him? I would imagine if there were an argument, did he actually pardon him? Let's just say, hypothetically, Trump tweets out a pardon. I don't know if there's any formalities for a pardon, but the guy says, "Oh, he just pardoned me," and Trump says, "Oh," and then other people say, "No, he didn't pardon him. Trump doesn't talk for whatever the reason." Then I suspect that issue would be justiciable. Was that a pardon in the sense of the Constitution? And the court will interpret the act to determine whether or not it was a pardon or not. And if it deems it to be a pardon, unattackable. If it deems it not to be a pardon, not an issue. When it comes to the terms high crimes and misdemeanors, I think I'm going to get stubborn and say I will never accept any idea that says it means whatever Congress wants it to mean, because then if it did, there was no point putting those words in the Constitution in the first place. You could have just said they can impeach for whatever reason they want, but they put in the words high crimes and misdemeanors to have a meaning and not one that would be undefined and susceptible of whatever the whim of Congress was.
It's
tell me I'm wrong.
No, it's funny because usually when this was even presented, a lot of people have a hard grasp of this political question doctrine, because you're right. There are words there. High crimes and misdemeanors mean something. It does mean something. But like my constitutional law professor said, you know what it means? It means exactly what those who are allowed to interpret it means. Because even, I don't know if you guys, well, I'm assuming you guys have mistake of law too, where you have the one guy, he reads the law book, he'll say it means this. Like we have a big case here in New York where he wasn't a cop, he was a corrections officer, he's a federal corrections officer. And the law in New York said, well, if you're a corrections officer, you can carry a firearm on and off duty. But that law was interpreted by the court system to only mean state corrections officers, even though the law itself just said corrections officers. There was a judge and there was a ruling back, like 20 years ago where the high court in the state said that only meant state corrections officers. So this guy was a federal corrections officer. He went to the gun shop. They read the statute. He went to the cops. They read the statute, and he carried a gun and was arrested and charged with that particular crime. And and it was called mistake of law. And the court in that case, the court said he, even though he's right, a plain reading of it means something, but he does not qualify to interpret the law. It is the courts who have that authority. But in this situation, when it comes to impeachments, it's not the courts. Unfortunately, it's Congress, because it's a political question. Just like how we accept the courts have that role to tell us what the law means, even though it may say something different. In this particular instance, we have to, the courts have said, the courts, and not a unanimous Supreme Court has said it's Congress who tells us what that means.
I'm going to have to read that particular Nixon decision because I refuse to accept the conclusion. And it may be, it's not political bias because there's no politics in it. It's just, it doesn't make sense. There are words there. They have to be interpreted and not disregarded.
But then it becomes the question, interpreted by whom? And that's the operative question. Who gets to make this call as to the language, was Nate's point. And if you say, well, the House has the sole power to impeach, which it does, and the Senate has the sole power to try, which it does, then sole suggests sole. And to the extent that they're making a mistake, they are the court of last resort. They're sitting as a court. This came up in Clinton's impeachment trial, where someone called them members of the jury and someone objected and said they're not jurors, and the rank West at the time said they're not jurors. You are the court. You are sitting as a court, and don't refer to them as jurors. So it's like, who gets to make this decision? And the Supreme Court normally interprets the Constitution, but if their interpretation of the Constitution is that sole means sole and it's wholly committed to the legislative, then I think that's fair. And the idea that some judicial power should exist in the legislature, to the extent this is judicial at all, is not wholly belied, because the pardon power is often considered judicial power, which belongs to the executive. So some judicial power might not vest necessarily in the judiciary, but that's the way the Constitution sets it up. So I'm forced to agree with Nate and disagree with you, Viva.
It doesn't matter. I'm stubborn. I'm going to stick with.
Okay.
There's no other explanation that makes sense. But hold on.
Barnes got you, huh?
Logic has got me. Words have meanings,
okay,
or they don't. But hold on. Okay. Al Dente says, "Is it possible that Schiff can be charged with sedition for the circus?"
No.
George Orwell, 1984. Very nice avatar. I'll predict the answer from the two American lawyers. No, because they're acting in their capacity as politicians. But
also, I don't believe sedition is a federal law at this point. There was the Alien and Sedition Act way back when, but I don't think sedition is on the books right now. So there's that.
We got, by the way, thank you very much for the super chat. Dude XO1, have you seen the SNL skit on Alan Dershowitz? Can't click it right now. To attack him. Was it fair to attack him on his former clients?
Yeah, premise of the skit is Alan Dershowitz goes to hell and all his former clients are there. And the guy who also made Baby Shark is there because why not? And so they're attacking him on his evilness for his past representations. And I default to what I said earlier. A lawyer is not his client. A lawyer represents his client and puts forward the best case for his client. And if Alan Dershowitz is the best lawyer, let's assume, then it makes sense that people who are the most hosed would want him. And so he'd have a lot of difficult cases. But if he's good in presenting the legal arguments and representing his clients, that's kind of what he's supposed to be doing, unless you want to argue that certain people shouldn't have representation or should have less than optimal representation.
So don't get me wrong. No, I just want to say Alan Dershowitz, even though I disagree with him with this, if I was in trouble and you can get me Alan Dershowitz, that's who I want. You know what I'm saying? Just because we disagree with him doesn't have any stature on the type of attorney that he's a fabulous, probably one of the best attorneys in the country. So, but again, I just disagree with him with this particular point.
And I'll just highlight something I've mentioned in previous vlogs. And I know I take a lot, I poop a lot on lawyers because they're annoying people, to put it very, very mildly. But there's a difference between representing, call it a bad client for lack of a better word, or a guilty client. And there's a difference between representing a client in a bad manner or in a guilty manner. And you can represent a client who may be guilty on totally legitimate means. And it's different than representing even an innocent client using illegitimate means. And people like to shit on I'm done. People like to poop on lawyers and they like to call them names. And they like to get mad at them for using technicalities to get their guilty clients off. But they are, to some extent, ensuring the due process that should be applied to everyone, guilty and innocent alike. Because if you let improper process affect and condemn a guilty person, it's only a matter of time before it comes down on an innocent person. And that's the biggest distinction. It's I don't know who Alan Dershowitz defended except for one big name who he might have, I don't know what his relationship was, but
O.J. Simpson?
No, well, forget O.J. Simpson. One thing's for certain, whatever came out of O.J. Simpson's acquittal, they put in protocol to ensure that the mistakes that happened will never happen again.
Yes.
And no comment on the rest of it. But no, I mean, look, a lawyer can defend a guilty person on legitimate bases, or they can defend a guilty person on illegitimate bases. And that's where it becomes a question of the morality of the lawyer. I don't know Dershowitz's morality in general, but yeah, I don't think it's fair to attack a lawyer based on who they represent, but rather based on how they represent those people.